So Karen, if you can. Okay, good morning. Welcome to the Committee on Veterans and Legal Affairs. Today we have a few language reviews and a work session on LD 554. Looked like that's it for today, and then tomorrow we'll be meeting again. But before we get into the agenda, we can first start with committee introductions so everybody knows who we are. We'll start with the House Chairman, Chiazzo.
Thank you, Mr. Chair. Good morning, everyone. Chris Chiazzo, House District 28, beautiful West Scarborough. Apparently, weathermen and baseball are the only professions where you can be wrong 70% of the time and still be employed because it's really hot here today.
Well, our AC wasn't working at the State House. It's a little bit warm. Starting to cool down now, though. So, Senator Farron.
Good morning, everybody. And I would say I'd add politicians to that list too, but that's just my personal opinion. Brad Farron represents Senate District 3, which is the majority of Somerset County and the town of Rome in Kennebec County, and look forward to working with you folks today.
Representative Supika.
Good morning, I'm Laura Supika, and I represent House District 126, which is a portion of Bangor.
Representative Kinney.
Good morning, I'm Marianne Kinney. I represent House District 99, which are 9 towns in western Waldo County.
Senator Hickman.
Good morning, everyone. I'm Craig Hickman. I represent Senate District 14, 11 towns in southern Kennebec County, including my hometown of Winthrop on the Lake.
Representative McCrate.
Good morning, I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House.
And Representative Wood.
Morning, I'm Barb Wood, and I represent House District 38, which is here on the western end of the peninsula in Portland.
Okay, and my name's Louis Lucchini. I represent most of Hancock County in the state Senate. With us today, we have our committee analyst, Janet Stocco, and we have our committee clerk, Karen Montel. All right, and we do have a number of members, I will say, who double on multiple committees, so you may see us popping in and out all day as we work through bills. It's kind of a busy time of session for us. So with that, I think we will move into the work session on LD 554, an act to create gaming equity and fairness for the Native American tribes in Maine. This is Representative Collins' bill. And we did an initial work session last week, and we kind of ended early, and we just, before the Attorney General's office, we had requests to have them give us input on the bill as well. So we've brought in Assistant Attorney General Kimberly Pat Warden, who is here to, they don't have a position on the bill, but just to give us input so that we can make sure we craft the best legislation that we can. So with that, we'll bring Assistant Attorney General Pat Warden into the meeting. And also, sorry, I should also make note, I do want to recognize that today we do have in our committee, we have the tribal chiefs. We have Chief Francis from the Penobscot Nation with us, as well as Chief Peter Paul from the Aroostook Band of Micmacs. And looks like we have Chief Clarissa Sabatis as well from the Holton Band of Maliseet. So thank you all for joining us today. So Attorney General, Assistant AAG, Pat Warden, thank you for being here. I know we had the request to hear input from your office, and you've worked obviously on this issue with the Judiciary Committee as well. So I just wanted to give you the floor if you had concerns or around drafting or anything of that nature, and we can also do questions, whatever's easiest for you.
Sure. I can start, and then I'm happy to be interrupted at any point. My name is Kimberly Pat Warden. I'm an Assistant Attorney General. I'm one of the AAGs in our office that works on tribal issues. So I just want to preface everything that I'm about to say with this sort of with this statement, which is that the Attorney General's office does not take any position with respect to this legislation. These are policy calls for the legislature about under what circumstances the tribes will conduct gaming within the state. So my comments are really directed towards drafting issues. And there's kind of two goals, is that the AG's office wants to provide our analysis of the bill so that the committee understands what the bill does in our view. And number two, because it is a gaming bill and seems likely subject to challenge, that we also want to identify some areas that would be potentially legal vulnerabilities with the language, so that the committee can choose to address those issues in some way or not. They're prerogatives that the committee has, and we want to provide information. But again, we are not taking a policy position one way or another with respect to tribal gaming. So having said that, sort of the first sort of overarching comment that I will make is that there have, and this, you will see this in Janet's analysis of the bill, both in her original analysis and also in the subsequent analysis, but the AG's office has identified as of one potential issue is whether or not this is the type of amendment to the implementing act that is permitted by the corresponding federal act. So Congress has given the state and the tribes permission to amend the implementing act in certain ways. And this is an area that may not be within those ways. So, and the consequence of that is that if the amendments that are made to the implementing act are ultimately determined to be ineffective, and that would happen in court, most likely, then the consequence of that is that the state, because of the way this bill works, the state has effectively repealed its gaming laws with respect to gaming activities by the tribes on their respective lands. So with the assumption that a new regime will be put in place, and that is the Indian Gaming Regulatory Act. If that is not effective and the Indian Gaming Regulatory Act does not apply, then the state has still repealed its laws with respect to gaming. That could leave a situation wherein the tribes would be able to conduct gaming without any regulation under IGRA or without any regulation under state law. This is kind of what's referred to as sort of like what's called a cabazon sort of state of gaming. That's the gaming that had been already going on before Congress enacted the Indian Gaming Regulatory Act. So there is a potential that if the amendments are ineffective in some way, there could be a sort of a vacuum of state and federal law that could apply with respect to gaming on tribal lands. So there are a couple of ways to address this. Janet suggested in her OPLA memo a severability clause. In addition to that, the committee could consider adding a contingent repeal provision, such that if a court of competent jurisdiction ever decides that what the state has done and the tribes have done trying to make IGRA effective in Maine didn't work, then those provisions of the Maine Implementing Act would be repealed, so that there would not be sort of that vacuum of no state law or no federal law applying to gaming activities on tribal lands. That is a possibility that the committee should or could consider. The committee also does not need to consider that at all. It is a policy call about whether or not you want to try and address that potential outcome. The outcome that says if a court says someday that IGRA doesn't apply, that the state's laws would then sort of snap back into place. So that's one issue with the bill. I would say the second issue is that I know this is the bill's intent, but I don't think it directly affects the jurisdictional issues. And I think this is a very simple fix. but the bill could more clearly state that the tribes will have jurisdiction over gaming activities within Maine. What the bill says right now, it just says that, that governmental responsibility and jurisdiction will be pursuant to the Indian Gaming Regulatory Act. The Indian Gaming Regulatory Act doesn't address jurisdiction. It acts on top of existing jurisdictional relationships. So in determining under the Indian Gaming Regulatory Act whether a tribe meets the qualifications under that act, courts will look to other provisions. It might be a state settlement act, it might be a treaty, but they're not looking to the Indian Gaming Regulatory Act itself for those jurisdictional aspects. So in the case of Maine, a court would be looking at Maine law and in the implementing act in particular and the federal counterpart. So they'd be looking at those provisions to see who has jurisdiction. I think that there can be a little bit more clear statement about that the jurisdiction will be with the tribes to conduct gaming activities, and more particularly also can specifically address governmental responsibility, enactment of ordinances, so that the legislation makes clear that those two aspects with respect to gaming lie with the tribes. And again, that's to avoid a potential legal vulnerability to the bill and the conduct of gaming by the tribes in the future. It is, but again, this could be done a number of different ways. There is section 6204 of the Implementing Act, which says generally that state law applies. There is also another provision of the Implementing Act, section 6206A, which says that in particular with respect to the Holton Band of Malice seats, that particular tribe does not have the power to enact ordinances. Now that particular provision of the Implementing Act is a subject of dispute as to whether or not that particular provision of the Implementing Act is effective. And this is not the AG's office doesn't view this place to be the time to litigate that dispute. But I want to tell you that there is a dispute about that. And because there is that dispute, it is also a potential area for legal vulnerability to third-party challenges to tribal gaming. So, again, this is an easy fix. It's just making sure that the amendments that go into the Implementing Act eliminate that argument. So it's just saying, could possibly be language saying that the tribes have jurisdiction and have powers to enact gaming ordinances. That can be language that can be worked out. Again, a way to avoid potential challenges to the conduct of gaming should this bill pass. And there's, Janet addressed this in the supplemental memo, but there's language in this particular bill that talks about gaming operations versus gaming activities. And the AG's office is still not entirely clear on what kind of activities fall within these categories, right? And this is important because the state is going to be repealing its laws with respect to gaming activities and with respect to gaming operations. That could be very broad. It is, again, just a caution for the committee about what potentially it is doing, so that the committee kind of understands or can inquire further as to what those two things are, because it could, again, be a potential area for litigation in the future. And that would probably be litigation in between the state and the tribes, whereas probably the conduct of gaming itself would be litigation most likely between a third party and the tribes. But this area of jurisdiction and what laws are being repealed or not is an area that we think should have more clarity. And I know that I've seen the amendment with respect to the Micmacs, and the AG's office agrees that with the analysis that Janet has provided is that there isn't permission in the Federal Settlement Act to amend the implementing act with respect to the heuristic band of Micmacs. So I just don't see, don't see that it's possible that this amendment can include the heuristic band. Congress has given the state permission to amend the Micmac Settlement Act with the agreement of the Micmacs. But in the past, the Micmac band has taken the position that the Micmac Settlement Act is not effective. So I'm not sure if that's a viable option. Senator Lucchini had asked if there are other options. I think one option would be to, enact a comparable provision of the amendment that you have in front of you outside of the main implementing act and outside of the Micmac Settlement Act. Of course, the legislature could choose to amend the Micmac Settlement Act, and then the band could choose to approve that or not. And then the committee could also, in conjunction with that amendment, could enact perhaps within a new chapter within Title 30, a new section that would address the Micmacs in that particular provision. So that's another option. And in that respect, with the Holton Band as well, the Holton Band also technically, there isn't permission to amend the main implementing act with respect to the Holton Band. So, that is another potential avenue that could be explored with respect to the Holton Band as well. Amending the implementing act and then in tandem enacting a standalone provision with the same substance as what the amendments to the implementing act were, in order again to ensure that if there is some sort of challenge going forward to this legislation, that there would be a backup. So that it wouldn't simply be, this is ineffective, okay, let's, and that's the end of the ball game. It would be, okay, here's a primary argument, and then here's a backup argument. A belt and suspenders approach, as we lawyers colloquially say. I can answer any questions anybody has, but I think those are the high points.
Thank you, Attorney General, Assistant Attorney General, for your input. Representative Chiazzo.
Thank you, Mr. Chair, and thank you for being here on behalf of the Attorney General's office. A quick question that I'm kind of wondering in terms of the existing Claims Act for, I believe it's the Penobscot and the Passamaquoddies. I think the question is, do we need federal approval to have a state agreement first, or do we get the state approval first? Does this agreement require any kind of federal authorization for the existing Indian Claims Act?
With respect to the Passamaquoddies and the Penobscot Nation?
Correct.
No, the Congress has allowed us to amend the implementing act with respect to the Penobscot Nation and the Passamaquoddy tribe. Having said that, again, it's not clear that what this bill does falls within those particular provisions of how we can amend the implementing act. If the clear-cut way to make the Indian Gaming Regulatory Act applicable in the state is to go to Congress, is to say Congress, reach an agreement and then ask Congress to amend the Indian Gaming Regulatory Act to make clear that it applies within the state. And then there isn't any question anymore about if what the state does is going to be effective or not, because Congress has answered that question.
Thank you.
You're welcome.
Okay, any other questions from committee members on this? Senator Farron.
Thank you, Mr. Chair. I guess it's kind of a follow-up to the House Chair's question. So would it be cleaner, in your opinion, cleaner or more protection for the citizens of the state of Maine to get that determination first before we before we move forward with legislation?
I'm not sure I understand the question. Are you saying that, are you asking if we should ask for some sort of guidance from the federal government?
Or that they would agree to the modifications to the Claims Act?
I'm not sure that avenue is possible. It's certainly possible to go to Congress and ask them to amend the Indian Gaming Regulatory Act to make it applicable in Maine. And then none of this bill would not be necessary. It would be a clear-cut, simple action if in order to make IGRA applicable in Maine. The bill does this in sort of like a different way. You know, it works within the framework of the Settlement Act in order to try and make IGRA applicable in Maine. It may be effective, it may not be effective, but certainly asking Congress to amend IGRA to make it apply here would be effective.
Representative Chiazzo.
Thank you, Mr. Chair. So if we proceed with this and we assume, or we presume, I guess, that the state has authority to implement this under IGRA, who would challenge that? Would that be a private third party that would challenge that, or would it need to be challenged by either the state or the federal position or the tribes themselves?
I am assuming that where that challenge would come would be in, if this bill passes and then a tribe submits a gaming ordinance to the National Indian Gaming Commission, to the Gaming Commission, and the commission approves that ordinance, that there can be challenges to that through the Federal Administrative Procedures Act. So in some states, those challenges have come from citizen groups. Sometimes they have come, or potentially it also could be a challenge by a casino or another entity that is operating a casino. But those challenges probably would arise, most cleanly would arise in an APA action, in a challenge to the action of the Gaming Commission.
Okay, thank you.
Representative McCray.
Thank you, Mr. Chair. I don't want to ask you to repeat it all, but I heard that there were several ways to craft this to avoid the possibilities. So I'm not going to ask you to repeat that, but I wanted to make sure, Mr. Chair, that we could ask Attorney Hinton to come in to give us some information around his thoughts on this.
Yep, we will. Yep, we'll just get through questions with the AG's office first, and then we can bring in Mr. Hinton. So I guess AAG, in terms of the contingent repeal provision and the, I guess the idea that it could fall back if it's struck down by the courts, that would fall back on no regulation. I was trying to think if we could create kind of a fallback clause that would say if it did get struck down, then state gaming laws would apply type of situation. If that would give some ease, I guess, to people that rather than IGRA governing the tribal casinos, they'd fall under state regulations.
Yes, I mean I guess it would depend at that time, what those state regulations were, but certainly that's a possibility. But the concern would be, of course, if what the state does here and the tribes do is not effective at making IGRA applicable, to ensure, if the committee so chooses, that there is a contingency in place so that it's not a situation where there's no IGRA framework or state framework, if that is what the committee wants to do.
Representative Chiazzo.
Thank you, Mr. Chair. You mentioned two possible solutions to that, a severability clause or a contingent repeal clause. Could you highlight are there any differences between the two in terms of applicability or desired outcome, or is it merely just a language question? And would the AGs have a preference on either severability or contingent repeal, or do you not have a position on that?
You know, I'd have to think about it more, so I can get back to the committee if there's sufficient time for that. But I don't have an answer right now.
Could you just, if you can, briefly just describe the potential differences between the two, if you can highlight that without getting into detailed legal analysis? You know, what are the basic differences between the severability clause and the contingent repeal clause from a bigger picture perspective?
Yeah, so you know, a severability clause is possible, and I'd be interested to hear what the attorneys for the tribes and what Janet might think about this, because I think a severability clause was something that she had thought about as well. So a severability clause would say that you know, if a certain provision is found to be ineffective, it doesn't, you know, affect these other provisions of the act. But I'm not sure how that would work in this particular context, because, you know, with respect to the whole point of this is to have IGRA apply. So if IGRA doesn't apply, then I'm not sure what the other parts of the bill how it would work, right? So, and then with a contingent repeal, it would just be, if a court of competent jurisdiction ever says this, then all of these provisions that have been enacted are now repealed. So, you know, maybe there is a better way to craft a severability clause, you know, in the context of this bill. But, you know, the purpose of this bill is to make the Indian Gaming Regulatory Act apply in Maine. If the state wanted to, or if the committee wanted to pursue tribal gaming under state law, then that's another option that doesn't require any amendments to the implementing act at all.
Follow up, Mr. Chair?
Yep.
Thank you. So are there any, I assume we can do this, it's a bad word, I know, but a severability clause or a contingent repeal clause doesn't need to be all or nothing, right? You could have specific components of the law that are severable or repeal based on those particular aspects being not applied, not the entire law, or would it be cleaner just to say, if one aspect of these several points becomes not applicable, then the whole law is rescinded or repealed?
I'm just not sure. I apologize. I can't give you an answer on the spot.
Okay.
Yeah.
Thank
you. Senator Hickman.
Thank you. Thank you, Mr. Chair. Thank you for being here. Assistant Attorney General, I do not want to try to pronounce your name, and I apologize, but I don't want to get it wrong. I think that I'm hearing you say that this bill may be effective in producing its intent. It just may not be, but it might be. And that the only way we would know about that would be to implement it and see if it survives a challenge in the courts. Is that safe to say?
I think that's a fair characterization of what I've said. I think there's also ways that the bill can be improved to survive those potential challenges through litigation.
I think the jurisdictional question, for me in particular, is the most important to get right. That's just my opinion, but that one is important for sure, to make sure that the language is clear on jurisdiction.
No, I agree, because there are provisions of IGRA that require jurisdiction to be in place. You know, there has to be, the definitions within the statute require there to be jurisdiction, and they also require the gaming activities to take place on Indian lands, which is, again, a defined term. So yes, there should be, you know, clarity that there is, that all of the prerequisites for the Indian Gaming Regulatory Act to apply to tribal lands are met through this bill.
Thank you.
And regarding the jurisdictional pieces, it seems like it's kind of doable from what you were saying. There's some ways we can perhaps clean it up to make it clearer.
Yes, it might require some other amendments to various portions of the implementing act as well, just to clarify. So I had mentioned 6206A. There are also some tax portions of this bill, which could potentially be inconsistent with section 6208, which applies to taxation. So, again, it might require some additional amendments, just, notwithstanding any other provision in this particular act or something like that, in order to avoid those potential inconsistencies between other provisions of this bill and the implementing act.
Great, thanks. Other questions? Representative Kinney.
Thank you, Mr. Chair. You've mentioned a couple of different things. Is there a difference between trust land and tribal land?
So there's a lot of shorthands that we utilize. Trust land, tribal land. The implementing act utilizes different phrases. It talks about Indian territory and trust land, the Holton Band trust land. All of this language is intended to encompass the concept that this is land that is either held in trust by the federal government for the benefit of that particular tribe, or it is what's called a restricted fee. So that's, I think, only the Passamaquoddy and the Penobscot Reservation. So it is just it's land held in fee, but there is a restriction on alienation against it. So, when we say trust land, tribal land, I'm probably not being as accurate as I could be, but it's just a shorthand for encompassing those two concepts, right? The land that is held in trust by the federal government or has a restriction against alienation.
Quick follow-up, Mr. Chair. Thank you. You're on mute, by the way. So I guess one of the concerns, and I've heard it brought up before, if the tribes were to purchase land outside of their trusted land from the federal government, their tribal land, so to speak. So, for example, in Portland, Maine, that they purchased, if as a tribe purchased some land that they wanted to try to do something along the lines of what they're able to do with IGRA, or with if we pass something with this, that they could do on tribal land, but that's not technically their tribal land, it's just purchased land. What kind of implications could happen in regards to if we pass something like this for land outside of their tribal jurisdiction?
Right. So the Indian Gaming Regulatory Act only applies to certain lands. It does not apply to lands that are held in fee by a tribe. So right now, the way the implementing act works is that with respect to the Penobscot Nation and the Passamaquoddy tribe, there are certain parcels that are available to become Indian territory, up to a threshold of 150,000 acres in the state. My understanding is that neither the Penobscot Nation nor the Passamaquoddy tribe has reached that 150,000 acre threshold, but none of those areas that are currently designated to become Indian territory are in downtown Portland. But to the extent that the definitions of Indian territory change over time, it also changes the geographic scope of this bill. So there are additional bills that are pending in this legislature and that were worked in the last legislature that would have amended those definitions. So it's something to be aware of, that where the tribe can acquire land so that it can become Indian territory or trust land will also affect the tribe's ability to conduct gaming in those areas. It becomes a potential place where they could conduct gaming because those are lands that are acquired pursuant to a settlement act. And that's one of the exceptions within the Gaming Regulatory Act for where the tribes can conduct gaming.
Representative Wood.
Thank you, Mr. Chair. I just wanted to speak to Representative Kinney's question about the land. I actually had a bill this year, LD 159, which was called an act to eliminate time limits for placing land in trust status under the Maine Indian Claims Settlement. And when I worked on that bill, I did look at maps of the state where all these parcels of land exist, and none of them exist in what I would call southern Maine. So there's no concern about Portland, Lewiston. They're all very rural parcels. Some of them are quite small. And I think that the tribes are more interested in getting money to purchase these parcels that are being held in trust than I think adding more land to the list. So I just wanted to clarify that.
Great, thanks, Representative. And also just for members' information, in Janet's original analysis, she kind of walks through some of the requirements for which lands can be used under AGRA. And I think, Janet, that's from it's been a few weeks now since we had the public hearing and first work session, but that kind of outlines some of those requirements under federal law. Okay. Are there any other questions for Assistant Attorney General Pat Warden while she's here? Okay, seeing none, thank you for taking the time and speaking with us today and helping us try to identify any issues and make as tight of a bill as possible. So thank you. Yep. And
just on what you just said, there is a link in the bill analysis to the task force website. So the task force was the larger look at restoring tribal sovereignty in Maine. And there's a link on page 9 of the bill analysis to that website where the maps are posted for all except the Aroostook Benefit. So the other tribes, all their lands, they provided maps to the task force. And so you can find and see those maps there.
Great, thanks, Janet. That was page 9, you said? Great.
Thank you. I appreciate your time. I can remain available if you want me to hang around in case there are other questions. I'm happy to do that, or I can also sign off.
Great. Yeah, if you're good to stick around, that would be great in case we have additional questions, and if there's anything in the next day or so, if we can bounce it off you. I know our times are a little tight at the moment, but we'll try to. We appreciate any help you can, or guidance you can give. So, thanks. Great. So, Janet, did you want to add anything, or we can?
No, I just wanted to point out I did send a follow-up memo, and that's up on the web. So people obviously kind of have seen it if they wanted to. And if you're watching now, this is all on the electronic committee LD file for LD 554. And it just does explain that when I mean, I'm not going to go through each part of it, but I did want to say when I originally looked at the bill, the way it was originally drafted, probably because I was in the mindset from the 129th legislature where AGRA was one piece of a larger bill, I viewed the language about AGRA applying to gaming activities within the state and then state laws about gaming activities that were inconsistent would not apply. I viewed that in a very narrow sense of just literally, can you have a casino or not? Is there a revenue cascade that would be imposed by the state on the revenue or not? And I view that very narrowly. And I actually find it very helpful, the proposed amendment from the tribes, both versions, in clarifying exactly what they meant in the draft of the bill, that it applies to gaming operations and which state laws apply and don't apply. So when I went through the memo and I explain and give examples of state laws that would or wouldn't apply, it wasn't at all meant to be a critique of that. It was just to explain that it's a lot clearer in the amendments which state laws would apply or not apply. And so you can make a more informed choice, I think, when you look at that, about what you want to do moving forward. And then as far as talking about potential challenges, I just did want to make you aware of some potential challenges, because not because I agree or disagree with them, but because I think in this area of the law, it would be naive to think that there won't be a lawsuit brought by a potential interested party. And so knowing that possibility is quite large, it's helpful, I think, for you all to know what potential challenges are and then possible solutions. So I did just want to say that as far as the severability clause, under Maine law right now, all session laws that you enact are severable, which means if a court says, if you were to have 3 sections in a session law, and a court says section 1 is unconstitutional, you know, if you think of all the campaign finance bills we talk about, that's always a potential risk. Sections 2 and 3 are not struck down by that decision. So that's the general rule. All laws are severable. So I actually proposed a non-severability clause, which is the opposite, which is to say, if a court says any piece of this legislation doesn't work, then all of it doesn't work. I actually, and that was a suggestion from another person in our office about how do you deal with this potential issue. I think a contingent repeal clause, at least as far as administering the statutes, is a little bit cleaner, because then under a contingent repeal clause, the way you draft it is you say, if a court makes this decision, then the whole act would be repealed. And it would have something in it that requires somebody to notify the reviser of statutes and the Secretary of State and everyone else. So then there would be a clear record in the state about whether the statute is effective or not. I don't know if a contingent repeal or a non-severability clause has any other difference, but that's a difference that occurs to me, is it helps inform the reviser of statutes, for example, that this law is or isn't in effect, and that you may find helpful. I know the reviser would find that helpful. Then also, if you do make a contingent repeal clause, I heard Senator Lucchini say maybe you could have some kind of backup. So I did speak to the reviser of statutes about that potential possibility in case that were to come up. And it is entirely possible that you could say, okay, if a court strikes down AGRA as applying in Maine because a third party challenges it, then the state has said, okay, we're going to repeal this part. You can make a part A be all of the proposed amendments to 554. You say, okay, part A won't be effective anymore, but we're going to have a part B that's only effective. So it's a contingent effective date. It's only effective if a court strikes down part A. And then part B could be a backup plan. And you could decide as a policy matter what you want to do in that circumstance. So there wouldn't be, it wouldn't have to be all or nothing, I think is what I'm trying to say. So you can make a backup plan if you want. That's entirely up to you. And then as far as the part of the memo when I talked about the Aroostook Band of Micmacs proposed amendment, I would say, I think it's, if you do look through the memo, I think it's a very interesting question about whether the Maine Indian Claims Settlement Act allows the state and the tribes to decide that federal law, the AGRA, applies in Maine. So all of the things that Assistant Attorney General Pat Warden was saying about what advance consent did Congress give to amending the Maine Implementing Act to make different jurisdictional agreements. Well, if you step back from that and look at the tribe's argument that they have made for how you can apply AGRA in Maine, what they're saying is, under the Maine Indian Claims Settlement Act, the reason AGRA doesn't apply in Maine is there's a provision of that, it's section 16B, and it says, any federal law that's enacted for the benefit of Indians, if it affects or preempts the laws of the state, then it doesn't apply in Maine unless we said so. And that's what the First Circuit said when AGRA was passed. They didn't say this applies in Maine. So if you pass a state law, and we pass state laws all the time that affect tribes, or not we, but you all do. If you pass a state law that says nothing in state law is affected or preempted by AGRA, that would be a way to get federal law to apply. That's the tribe's argument. I just don't know if you have to put it in the Maine Implementing Act, if there are limits about what can and can't be in the Maine Implementing Act, maybe putting it somewhere else. And I think this is what Assistant Attorney General Pat Warden was suggesting as a possibility, maybe doing both, put it in the Implementing Act and put it outside of the Implementing Act. Then if you say that as a general rule, that actually affects all of the tribes equally. It affects the Passamaquoddies, the Penobscots, the Holt-Minot Maliseet Indians, and the Aroostook Band of Micmacs, because the Maine Indian Claims Settlement Act, that provision that prevents AGRA from applying in Maine, applies to all the tribes equally. So if you have a state law that says we don't view AGRA as affecting or preempting or having any conflict with state law, then all of the tribes would be equally governed. So it's definitely an interesting legal question. And because there are potentials for challenges in this area of the law, I felt like my role is to tell you all of the different ways you could possibly buttress the bill. So if you want to go forward with the bill, like Assistant Attorney General Pat Warden said, there's the belt and suspenders approach. So this is like the belt and the suspenders and the like extra, ropes and everything else. Just put everything on top of it to try and make it as protected from a challenge as possible, so that whatever your intent is has the strongest possibility of prevailing. And that would be why I made those recommendations. And I didn't put anything in about the ordinance authority, but I have been thinking about it. And that was where you were talking earlier about who has jurisdiction over passing ordinances or laws that affect tribal land with respect to gaming. And because there are provisions of state law and the Indian Claims Settlement Act that could be interpreted to suggest that the tribes don't have an authority, or maybe depending on which tribe, those arguments are stronger or weaker, I do think it would be helpful to add to the bill, nothing in any other state law. And if there's a dispute about whether a specific state law applies, just don't cite it. Just say no other state law. And then we don't have to talk about whether a disputed law is effective or not. Just say nothing in any other state law prevents any one of the federally recognized Indian tribes in Maine from enacting a tribal ordinance under AGRA, or from enacting other ordinances to effectuate Section 4B of the amendment, which talks about health and safety laws and different things like that, just to make it clear. And that doesn't necessarily have to mean you're weighing in on whether you agree that they do or don't have the authority. You're just saying, we're getting rid of that argument against it, is how I view that type of a proposed amendment. I'm not trying to suggest that I think the tribes do or don't have the ordinance authority. I just want, if you want this proposal to work, I would like to do everything possible I can to suggest to you how you can prevent it from a challenge. Or I think the challenge will be brought, but you can prevent the challenge from succeeding, if that makes sense.
Great. Thank you, Janet. Yeah, and as always, appreciate your thorough work. It's very helpful with us for trying to figure out the right solution. Representative Chiazzo.
Thank you, Mr. Chair. So, Janet, I wanted to follow up on the severability and the severability versus the what was it, the contingent repeal. You stated that obviously that's depending on a court challenge. I totally understand that. My concern was a statement I think made by the Assistant Attorney General that we would first, in essence, by passing this, would repeal the state laws in the Indian territories. And then if IGRA did not apply, those laws would still be repealed. Is that my correct understanding, or is that an incorrect understanding?
So I think you're correct in effect, but she was using a shorthand. So if you have either the amendment proposed by the Aroostook Band and Micmacs or the version presented at the last work session, you can look at either one. But it says in there, let me find it, because I'm nervous, so I'm having a hard time finding it. Okay. It says any law of this state that is contrary to this subsection or to any provision of IGRA or its implementing regulations, or that would be affected or preempted by the act or those regulations, does not apply to the conduct of gaming activities by, and then that would be the 4 federally recognized Indian tribes in Maine. So this language doesn't actually go and repeal all those statutes, but it says that they're not going to apply. And the worry is, in my office, we've talked about this. I've talked about this with other analysts, including the deputy director. And when he was speaking with me, he thought a court would view this legislation as a whole package, that you can't split it apart, that it wouldn't work. But the problem is there's a chance that the court could say it can be split apart. And so the first sentence, which says IGRA and its regulations apply in Maine, could theoretically be split apart from the second sentence, which says any law in Maine that conflicts with IGRA and its implementing regulations doesn't apply. So that's the worry, is are you then creating a situation where if IGRA is held not to apply, you've also said all the other state laws still don't apply. And so that's the reason you might want a contingent repeal. So then you would repeal that sentence too, even though a court didn't say it was ineffective.
Right. And my concern is that that's clear with a court ruling. If we're in a situation where we don't feel like we need federal approval to do this, we feel like, and the tribes feel like, that we have the authority to do this, Congress then decides, wrong, we disagree with you, you need to have our approval to do this. Have we now repealed all of our laws in the state? And if Congress does not approve, they're not the courts. Does that still trigger the severability or the contingent repeal clause?
So you're being very wise, and I hadn't thought of that, but that is a very good point. So there is no contingent repeal clause now, and I don't know if everybody's going to want one. But if you did want to put that in there, it would be wise to craft it not just to be a court. I hadn't realized before today about the Administrative Procedure Act provisions for challenging IGRA's applicability in Maine. So you'd want that to be covered as well, and you'd want congressional action to be covered. So it would just take a lot of thinking about how to draft that to be as broad as possible, if that's what you want. I don't know that everybody wants that, but if you did, we'd want to make it as broad as possible to cover every contingency. No pun intended.
And then I just so if I could follow up, Mr. Chair.
Yeah. Well,
just real quick, and I want to make sure that I understand this too. When we're talking about repealing the state laws for as presented in the bill and in the amendment, we're just talking about at the specific gaming facility, or are we talking about across all tribal lands, whether they have a gaming facility in it or not?
No, it's definitely tied to gaming facilities.
Okay.
I don't think there's any question about that. What the question is how broad that phrase gaming operations is. So I was reading to you from the first paragraph, or the lead-in, we would call it, like nerdy drafters would call it. That's the lead-in to subsection 4. But then there is the subparagraph, or it's actually paragraph B, which says that state laws don't apply to the gaming operations. And then if you look at that definition, that includes gaming activities as well as related and complementary services, businesses, and amenities to gaming facility patrons. And the way paragraph B is written, it's actually quite protective of state law, even though it sounds like it's saying state law doesn't apply. It is written in a very protective way to say if there isn't a tribal law or ordinance that's just as rigorous as state law, then state law is going to apply. But what's potentially out there is paragraph C, which does the same thing with tax law. And maybe that's not an issue because you don't feel like taxes should apply to these activities, in which case it doesn't matter. But that's where the definition of gaming operations becomes questionable if you want it to be that broad. And it may be that everybody always intended it to be that broad, but this is where I'm just sort of saying mea culpa. When I looked at the original bill, it never even occurred to me it was going to include the attendant services and amenities for patrons, and maybe everybody always understood that, but because I hadn't understood that, I felt like it was my job to let you know that is different from my original understanding, even if it's not different from yours.
Understood. Very thorough as always, Janet. Thank you.
Senator Hickman.
Thank you, Mr. Chair. I am really enjoying law school today. This is just excellent. And I think that what is happening through this bill analysis is a demonstration, because we have so many competent folks running us through this, is a demonstration of just how many tools the legislature has in its pocket to exercise its plenary power to control as much as it can possibly control without anybody else saying anything about it. And so belts and suspenders and clips and seams, I just want this bill as tight as possible with as much authority given to the tribes as possible. That's what I want. Thanks for all the ways that we can get there.
Great. Any other questions for Janet at this time? Okay, seeing none, we also do have Attorney Hinton here from, see if we can bring him in. And Representative McCrate, while we bring in Attorney Hinton, was there a particular area you wanted to start with, or?
Well, really, it's general. I'd like to hear Attorney Hinton's response to the ideas that have been presented to, as Senator Hickman said, make this as tight as possible.
Sure. So welcome.
Make it workable.
Yeah. Welcome, Attorney Hinton. Can you hear us? You're in. Yeah.
I can. Thank you very much. I'm really grateful to be here again with the committee, and I appreciate the prompt, Representative McCrate. I just want to start at a high level with the overarching issue of whether applicability of the Indian Gaming Regulatory Act in Maine is something that Congress spoke to when it gave its explicit consent to amendments to the Settlement Act. And I could summarize, but I actually think that the best way to do this is to read from federal law. The advanced consent of the United States is given to the state of Maine to amend the Maine Implementing Act with respect to either the Passamaquoddy or the Penobscot Nation, provided that such agreement is made with the agreement of the affected tribe or nation, and that such amendment relates to the enforcement or application of civil, criminal, or regulatory laws of the respective tribes in the states within their jurisdictions. The allocation or determination of governmental responsibility of the state and the tribe over specified subject matters or specified geographic areas, or both, including providing for the concurrent jurisdiction between the tribe or nation. I would note that with respect to the Halton Band of Maliseet and the Aroostook Band of Micmac, there are separate sections that are, all included within the Settlement Act framework as a whole. And those sections provide that the consent of Congress is given to authorize the state and the respective tribal nation to execute agreements regarding the jurisdiction of the state over lands held in trust for the benefit of the tribe and members. So that's the federal legal piece, the federal statutory piece. And now I want to draw your attention to the Supreme Court decision that Attorney General Pat Warden raised earlier, the Cabazon decision. That case, Assistant Attorney General Pat Warden, sorry. That Supreme Court case explicitly addressed the question of whether or not gaming activities are civil or are criminal in nature. And the Supreme Court ruled in that case that the conduct of gaming in a place where gaming is already legal is not criminal, it's civil and therefore regulatory. That decision prompted Congress to pass the Indian Gaming Regulatory Act. The Supreme Court was clear that gaming is very much a civil regulatory issue. So therefore, when you take that rule from the Supreme Court and you draw it back to the federal statutes that we're looking at here, it's clear that gaming regulatory issues would fall squarely within the advanced consents given by Congress to address civil regulatory issues between all of the tribes and the state, provided that the appropriate consents are given. So I would say that, you know, on the tribal attorney side, we've thought these issues through quite a bit. We've talked these issues through with the Attorney General's office going back some time now, going back to before the pandemic. And we feel that this explicit language regarding advanced consent is something that we're very comfortable to rely on when dealing with these sorts of issues, which are precisely allocating regulatory jurisdiction with respect to gaming, an issue that's already regulated in the state. So I'd start with that high level issue, and I can answer follow-ups on that, or we could delve into the other issues as committee members would like.
Sure, thank you, Attorney Hinton. Representative Chiazzo.
Thank you, Mr. Chair, and thank you, Mr. Hinton, for being available. I think your perspective is obviously extremely well appreciated, and I have no reason to disagree with your approach or your conclusion that IGRA this falls under the ability for us to do this. My concern is that, you know, we can't predict what Congress will do. We also can't predict what the courts will do. Do the tribes have a position, or would you oppose any kind of severability or any kind of those kind of fallbacks? I'd call them basically safety valve provisions. I know when you've talked in the past, and I every reason to believe the tribes are coming at this in good faith, and you've very clearly stated that this is just to start the negotiation process. Totally understand that. I don't want to handcuff anybody out of the gate. I'm just wondering what your position would be from your client's perspective in terms of having that severability clause in place. Would you be opposed to that, or is that something that you'd be amenable to?
Thank you very much for the question, Chair Chiazzo. I don't want to speak for the chiefs that are here, but I would say that the tribal attorneys, we've already been discussing approaches, language that could be crafted to address these very specific issues. Our approach to all of these discussions has been to be, you know, as transparent and constructive as possible about our approach. That's why we've been working with AAG Pat Warden, you know, going back a couple of weeks now on language here. So we're very much open to that. I think that our goal is probably the same as everyone here, which is to ensure that, you know, assuming a policy decision is made to open up this opportunity, that there's clarity with respect to jurisdictional and regulatory issues. And we certainly don't want a situation where third-party commercial challenges blow holes in this and make it unworkable for everybody, because that will only lead to more litigation. And so I will say confidently that, you know, I'm here to work between now and tomorrow with the other attorneys, with Ms. Pat Warden to clarify these issues. And I would also say that extends beyond the contingent repeal side of it, also to the clouds regarding jurisdiction, and whether or not the tribes have the authority, given these other implementing act issues, to actually execute and enforce the various ordinances needed. And I think that the tribal attorneys were all very open to making this as strong as possible. So we're here to do that work, and we look forward to it.
Thank you, sir.
Great, thank you, Attorney Hinton. I think it's really important that, as you said, that we're all kind of collaborating to make sure we get this as right as we can. So hopefully it can withstand challenges, which, as we know, are probably certain to come. Attorney Binney, did you want to weigh in on that question from Representative Chiazzo?
Yeah, I just wanted to say that, you know, I agree with whoever Janet had talked to on the severability issue. It's really about a non-severability clause. I don't see a court striking down, the first sentence of subsection 4 without striking down the entire subsection 4. So I think, Janet's point about severability, it's really about adding a non-severability clause. But I think, the goal here is to have IGRA apply in Maine, where the tribes are conducting gaming activities pursuant to their inherent sovereignty with the overlay of the federal restrictions, essentially how every other tribe's doing it in the country. And so I think that, from the attorney perspective, the tribal attorney perspective, we can work on some belt and suspenders. I think what we would need from the committee, though, is a direction to both Janet and the Attorney General's office to quickly roll up our sleeves today and try to come up with some belts and suspenders that we can add. I don't think Congress is going to have any issues here. My experience in working on these issues in the rest of the country is it's typically the competitors that have the concerns and bring the litigation. So I do anticipate that there likely will be some litigation. And so I think there's some other ideas that we can go through that we can do on a contingent repeal that allows, if a court did strike down IGRA, we could add a provision that allows the tribes to conduct gaming in the same manner as the commercial casinos that exist now until the state legislature can fix whatever problem a court may find. If a court finds a problem, we feel the language is pretty good, but we're happy to spend the next or the rest of today trying to clean it up a bit. And I think some of the suggestions being proposed by Janet and Assistant Attorney General Pat Worden are worth adding. So I think we could do that, but I think we would just need direction from the committee. I do know that the tribal leaders and the chiefs are hoping that there'll be a vote on this bill this session. So I just want to add that, I think from the attorney perspective, we're willing to kind of clear up our schedules the rest of the day and focus on this if that meets the committee's needs.
Thank you. Yeah, and I think any recommendations and solutions would be really helpful. I know everybody's super busy today, especially probably Janet with our other bills. So, but I'm sure we can be in communication. I'd love to hear whatever you have to say. And tomorrow is technically our last day of committee. And, as far as I'm concerned, we can vote with as clean a bill as we can get, but obviously we'll have time to floor amend and with any changes that keep coming. So we'll have other opportunities to clean it up and continue the conversation all the way up until adjournment to try to make the best bill that we can. And I don't know, I was going to ask Attorney Hinton as well on that, where I'd ask the AAG about if we were to do a contingent repeal, to have some sort of fallback that if the court was to strike down the IGRA portion, that we'd still want the tribes to have, out of fairness, gaming abilities. I mean, perhaps that's something we can wrap our head around and try to find a solution. I don't know if you thought that out at all, or.
Not specifically, Senator, but I would just say that the overall approach that we've taken here is to use really state law as the baseline. And so if in a contingent repeal scenario, state gaming laws were to be the backdrop and there was equality there, fundamentally that seems like it would be a good approach to take. Because it's consistent with how all the public safety laws must otherwise be, consistent with state law. So I think that's something that the attorneys, we would definitely, we look forward to digging into it following the work session.
Great. Thank you. Any other questions at this time for either of the tribal attorneys or any other elements that Attorney Hinton or Attorney Binney that you'd like to add at this point? Good. Okay. Well, thank you both for being here. And we'll continue these conversations and look to do something tomorrow. I know it's a really tight time frame, which makes it tough for everybody, but we'll try to be in communication to figure out the best way forward. So thank you.
Thank you very much.
Yep. Great. Okay, so we wanted to make sure to get more information on this. And my thought was that we would table it until tomorrow that will give us more time to think about this. So is there a motion? Representative
Motion to table.
Oh, sorry.
Beat me to it. Second.
Okay. So we have a motion to table by Representative Supika and seconded by Representative McCray. Karen, can you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren. Senator Farren, absent. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle. Representative Tuttle, absent. Representative Riley. Representative Riley, absent. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington. Representative Harrington, absent. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff. Representative Dolliff, absent. 8 in favor of the motion, 0 opposed to the motion, and 5 members absent, Mr. Chair.
Great, thank you, Karen. So we'll put this on the agenda for tomorrow. The exact time is uncertain at the moment because we are going to be also working on the marijuana bills, and we have to kind of coordinate staff to make sure we can make it all work. So we'll be here tomorrow morning. It's just the order. We just have to coincide with the Transportation Committee to make sure we don't have Sam in 2 places at once. And again, thanks to the tribal attorneys and chiefs. Thanks to the chiefs for being here. Thanks to the Attorney General for helping us craft this legislation. So I guess next on our list, we just have a number of language reviews. Is that right, Janet?
Right.
I guess we can start working our way through those.
So I meant to go in numerical order, sorry. It's the way my mind works. So the first one is LD 148, which is an act to establish ongoing absentee voting. There's a divided report. This is the majority amendment for 10 members of the committee who are listed at the top of the page. This is a strike and replace amendment. I might have already said that, which means that everything you see here is the only thing that will be left in the bill, which is actually sometimes helpful for you to follow it. The biggest thing to note is that the different provisions have different effective dates. So I tried to mark them on the side so you could sort of follow along what happens when. So section 1 talks about the information sharing with the states, which as we'll see later on in the amendment, you wanted to direct, or the majority wanted to direct the Secretary of State to enter into agreement with the electronic, I'm forgetting their name, Electronic Registration Information Center. I just think of them as ERIC, and the sharing of the information from among member states about who's been enrolled to register to vote in different states to make sure that we clean up the voter list. So that's section 1, and that would be effective January 1st, 2023. But the rest of the bill about actually ongoing absentee voting is effective November of that year. And so you also included in this amendment, we talked about this a couple of days ago, you included the provision that was originally in LD 451 and 456 that there can't be any mark on the outside of a return envelope that indicates the party of the voter if it's a general election. Just wanted to make sure general election was still in there. I wasn't seeing it right away. Okay. Then this is the application for ongoing absentee voter status. If you remember, this was amended to say you have to be at least 65 years of age or self-identifying as having a disability to apply for this status. You also asked to clarify that if a voter did not vote by absentee ballot in a general election, then their ongoing absentee status could be canceled. So that is included here in this amendment as well. And then I'm going to skip the star for a second. And then this is just talking about issuing of the ballots. And this is the provision that we talked about that's also in other bills about you don't have to issue a ballot if you're a clerk until the official ballots become available. So that's clarification in here. And again, it says that if it's a general election, you can't make any mark on the return envelope that indicates the party of the absentee voter. So then here in section 4, there is a star for a reason. So this part of the majority report includes something that was in the original bill, which talks about collecting the telephone and email contact information from an applicant for an absentee ballot or an ongoing absentee ballot. And this was in the original bill, as well as a provision about having rulemaking for the procedures to cure a defect in the absentee ballot. And that's why you collect the telephone number and email to contact the voter. So as written here, this is going to conflict with LD 1363's amendment because that can't say ongoing absentee ballot status because it can only talk about what's true within that bill, and ongoing absentee voter status is created in this bill. And where that other bill talks about the whole cure process and everything else, I didn't know if the majority members still wanted to include this because it will now conflict. In addition, whenever I draft an amendment, it goes through legal review internally, and the legal reviewer, and then I checked with some other people just to get independent eyes to look at it. They view the way this language is written as almost a requirement that a telephone number and email address be provided. And either I would suggest either clarifying it here if you want to keep it in LD 148, and then also clarifying it in 1363, because that's still in processing, that you don't have to provide a telephone number and email address to get your ballot. It's just an option. So rather than send this back to the revisor's office and change it up again and delay when you got to see the language, I just thought I'd ask because I didn't know if you want to still include this where it might be in conflict with the provision in 1363. It's not a fatal conflict. It's the type of thing, again, that can be corrected in the errors bill. So I just wanted to get some further guidance. But just to show you the rest of the amendment. So section 6 of the amendment requires the Secretary of State to enter that agreement with Eric, and that's by January 1st, 2023, which is why, if you look up here, the requirement to do voter list maintenance isn't effective until January 1st, 2023, because that's when the agreement has to be entered into by. So that's why there are all these different effective dates. It's to make it all work together. So the Secretary of State has this directive to enter into that agreement, and that's effective 90 days after adjournment because they need time to enter into it before January 1st, 2023. There is also an appropriations section, and this is the cost of entering into that agreement with Eric. So it's a $25,000 initial fee, and then $24,000 yearly fee is the estimate. So that's what this appropriation is about. And then this effective date provision, instead of you having to figure out which one went where, that's why I marked it up on the side. The fiscal note does just say what the appropriation section says. which is it's these costs. So you don't have to do anything with the section I starred, but I did just want to raise it to the people who are on this report and see what you think.
Thank you, Janet. I mean, I'm personally comfortable removing that if it makes it cleaner, but I will open that up to, and could you bring up to the top to see who's on the majority report again, please? Thank you. Okay, but certainly willing to entertain from those on the majority report. Representative Corey, I believe you are on as well, so please proceed.
Thank you, Janet. And I may have spaced out for a second here, but is the provision still in there that if somebody doesn't vote or return their ballot, I don't know if we required returning ballot, I don't think we did, that their ongoing absentee voter status? Okay, perfect, thank you. I'm good.
Corey, are you okay with removing section 4?
Yes.
Okay. All right, thank you. Representative McCray.
Thank you, Mr. Chair. Janet, can you scroll down to the starred piece again? Thank you. So I'm always worried that we'll lose something important because we don't know what's going to make it through and what isn't. So is it possible just to mimic the language in the other one? Did you say that already?
Yeah, so that's in processing, so I haven't finally decided how that language should read, but I could try and figure that out. And I mean, the original draft in 1363 from the Secretary of State's office made that very clear. Just some of the language in that didn't sound very statutory, so I think it can be some kind of hybrid of this language, which is very plain, and that language, which is very, you know, like if you wish to do it, then you can, you know, we can probably meet somewhere in the middle. And then I just hadn't viewed this as a requirement, but when 2 other people read it and viewed it as a requirement, that said to me, wait a minute, somebody's going to read it that way. I don't think that was your intent. So maybe we don't want this language the way it's exactly written now.
And it looks like it's requiring the person to provide. That's the question. Yeah.
Yes, I think it's because it's saying in addition to the other information required. Maybe it's just the word other that has to go away, but it makes it sound like maybe the telephone and email address are required when other people read this. Since I knew that wasn't the intent, it didn't even occur to me that that's how it could be interpreted. But since people have interpreted that, I think you probably don't want it to read the way it does now.
I'm certainly not a lawyer, but it says you must be asked to provide, not that you must provide. But again, look, you know.
That's what I had focused on, but I don't want you to be stuck with my interpretation if maybe other people don't agree. So
Representative McCray, would you prefer that we reword it along the lines of, what was it, Janet, 1363? I'm sorry, I can't remember what
yeah, I would just make sure, I'm already trying to make sure they're parallel, because that had been my instruction for 1363, but maybe getting rid of the word other would be enough. And I can run that by the people in my office who had concerns. And then if that's okay, then I wouldn't necessarily bring this language back to you. You just know the word other is going to go away. And if that convinces everyone, then that would be fine, because I do think it does say you just have to be asked. So.
Yeah, follow up, Mr. Chair.
Please, Representative McCray.
Thank you. Yeah, I don't mean to be labored, even though I already am, but I think if they're the same, that would make me the most comfortable, but.
Well, it can't be exactly the same.
Well, but what you're saying, that they would match in some way.
Yeah, and I want to be cognizant of staff time as well. By striking just the word other, I think we accomplished that similarity, don't we, Janet?
Yeah, I would just strike it in both, as long as the people on them. Well, it was clearly the intent in the other bill. There's no question in the other bill that the intent was not to make this a requirement. And what I did was take the 1363 and draft it to match this one. But by doing so, two people have said maybe you made it a requirement. So I don't want that to be, because that was not what anybody voted on to make it a requirement.
Yeah, I think I think we're on the same page in terms of the intent. I just don't want to have you create a whole bunch of drafting if it's easier just to strike.
It's not a problem. Don't worry.
Okay. Senator Hickman.
Thank you, Mr. Chair. Yeah, I think my concerns align with Representative McCrate's in the sense that there's no guarantee what will pass. So each bill should be correct in its own right. And then if we have to clear it up in errors, we should. But I do read this as a possibility of a requirement, just because it says, in addition to any other information required, this information is also required. I think that that's probably what the concern is. I don't know if removing other does the trick though, but I'll leave that up to you to figure out, because I know
okay.
You're pretty awesome about that.
So if I only remove the word other, I'm not
an option and not a requirement, that's all that needs to be.
And if I only remove the word other, I won't bring it back. If it has to look totally different, I might bring it back to you.
Okay, I'm comfortable with that. Is everybody else on the majority report comfortable with that?
Yeah.
I can't see everybody, but I see a couple of heads nodding. So if anybody is opposed to that, please say now or forever hold your peace. Okay. Any other concerns from the majority on that report? Okay. Thank you, Janet.
Okay, the next, yep, the next one is LD 860. So LD 860 is another divided report, and this is going to be a minority amendment for 4 individuals that are listed at the top in my terrible handwriting. So this is an act to clarify the laws concerning off-track betting facility licenses, excuse me. So the first part of the amendment clarifies, so the bill, one of the things it does is it allows the transfer of licenses between, from an existing off-track betting facility, they allow it to be transferred to a new licensee. And what the amendment does is it clarifies that that can only happen if the transfer occurs within the same municipality. So the new facility will be in the same municipality as the existing one. Another thing that this bill does, and I'm going to actually scroll down because it's been so long since we saw this bill, you may not remember. So there is a section 2. Sorry, there is a section 2 of the bill, which is not removed in the amendment. So it's still going to be there. And it's worth knowing so that you can understand the amendment. And that says that essentially Scarborough Downs, but an off-track betting facility licensed under Public Law 2019, Chapter 626, has all the same rights and responsibilities and privileges as any other OTB. So then you need to remember that's still in the bill, even with the amendment. And then what Section 3 will now do is amend actually Public Law 2019, Chapter 626 itself, because this had been a technical issue raised at the work session and the minority report said to clarify it. So the way that that reads is it says that this can be an OTB notwithstanding Title 8, Section 275D. And there's a lot of things in this law, including like whether minors can be present and everything else that you all didn't want to have not withstood. So we amend the public law itself and just say only the provisions that talk about initial licensure don't apply to this OTB facility. And then there is an attached fiscal note, and it just talks about minor cost increases that can be absorbed.
Thanks, Jenna. Can you go to the top again, please, so I can see who's on the minority report? Thank you. Any questions, concerns from those on the minority report? Let me see. Representative Corey, I think you're you got your screen on. Any concerns or questions from you, Representative Corey?
No. No.
Okay. Okay. Anybody else on the minority report have any questions, concerns?
Looks good to me as well.
Okay. Thank you, Representative Kinney.
Thank you. We ready for the last one?
Sure.
So this is LD 1575. Again, my screen is not cooperating. There we go. This is another divided report. This is a majority ought to pass as amended report for 9 members of the committee that are listed. And again, this is a strike and replace amendment. So you don't need me to scroll back to the original bill and show you what's still there. That makes it a little easier. So the first thing that this amendment does, if you remember, there's a provision in the bill itself that talked about a student photo ID being able to be used for proof of identity for voter registration. And that was part of this subsection 3. And you all directed me to make it its own subsection of law. So that's all this does. This is the same language that was in the bill. It's just now in its own subsection of law. The next part of the amendment, if you remember, the bill said that the locations, this is different. The original section 2 of the bill was different. So this provision of the bill talks about the instructions that the Secretary of State has to make to instruct voters about what are the excuses that can be used for absentee voting after the no excuse deadline. And the bill required those instructions, and where it put those in the statute was potentially going to create conflicts with other bills. So I just moved this to a different section of the law that talks about different instructions that the Secretary of State is supposed to make. So it seemed a natural place to put this requirement. The only thing is, when we were talking at the work session and I was trying to clarify, when the municipalities get the copy of these instructions from the Secretary of State, where are they supposed to post them? And it had said on signs at the municipal office, I believe, and we talked about whether that's supposed to be election related signs, all signs, not all signs. And I was very confused about exactly what everyone meant. And I checked with the bill sponsor who was on the committee and on the majority report, and she indicated that she thought the sense was it's just going to be on one sign in the office. So that's how I drafted it. But because I was confused, I just wanted to check with everybody that that was how they interpreted it as well. Not that I don't trust the bill sponsor, I do. I just want to make sure everybody knows. So that's just going to be on one sign. They can have it on more, but the requirement is one sign. Then the next part of the amendment, if you remember in the original bill, it talked about the notice of election, which is posted 7 days before the election, including certain information. The amendment, the majority report was to take that information and instead put it in the voting place report, which is 60 days before the election instead of 7 days before. So that's all this does. It talks about putting the location of each secured drop box and the times for in-person absentee voting as part of this report instead. There's also, in the original bill, there was a provision about nonpartisan observers, and you wanted to strike that and replace it instead with the Secretary of State being able to adopt rules governing poll watchers and others that are present in the polling place. And so that's what this does. And then the last part of the amendment was a direction to clarify the law to say that when absentee ballots are processed on election day, but before the polls close, they can't be counted. So they're all counting of all absentee ballots is after the polls close. So that's what this provision does. There is an appropriations section after there was a fiscal review, providing one-time funds for rulemaking and preparation of instructions. So I did star those to say this is the rulemaking that's involved in that fiscal note. And then the instructions, if you remember, were up here that are going to be used on signs and electronic and social media to instruct voters about the no excuse deadline. So those combined lead to an $1,800 fiscal note, which is now appropriation section, and also appears in the fiscal note itself, the $1,800.
Okay, thank you, Janet. Any concerns or questions from the majority report? Representative McCray.
Well, I'm disappointed to see a fiscal note. Maybe that's all I need to say. And that's because we added the rulemaking authority that the Secretary of State asked for.
and sort of focus a little
I don't know what
more
to
on
do other than lobby, but
acceptability or not of the
Yeah, I don't know if we can, I mean, I suppose you could appeal the fiscal note, right? But good luck with that, I guess. I mean, $1,800, I hope doesn't make or break the table, but you know, you never know. You never know. I think we can certainly add that to the list of things we want to advocate for on the appropriations. So.
I mean, it could be you could direct me to call the fiscal office and sort of challenge that underlying assumption, but it's really up to them whether they agree with the department that that is a cost. But if you want to instruct me to, then I can make that call.
I would love that. And they check with the departments about fiscal notes, right? So
yeah, I'm not sure of all of the details of their process. I do know that they check with the departments, but I think the final decision is the fiscal office's decision. So, I mean, I think I need the sort of the sense from the whole majority. I'm not exactly sure who I need permission from to call and challenge, but just let me.
My only concern is I would assume you have to have a basis for challenge other than we just don't like it, right? I don't want to waste people's time as we get close to, I mean, we are super in crunch time right now, right? So,
well, I think
if you think it's a good shot, Representative McCrate, and you want to write up a little blurb or something and send to Janet and say, we think it should be appealed because of X, and then I'm certainly comfortable with that, and I won't speak for the rest of the majority. I just want to be cautious that we're not piling it too high, Janet, because we've still got a whole bunch of other stuff left to do by tomorrow.
Well, I think it's perfectly acceptable to question a fiscal note.
Sure.
Because it's, is there really a need for that? I've done that before.
Yeah, no worries.
Thank you.
Absolutely. Chairman Lucchini.
Yeah, thanks, Mr. Chair. Yeah, I'm fine to see if they can make any changes or not. And, it probably came from the department, if I had to guess. But also, if we need, if it does hit the table, we can look at stripping out. That's probably around the poll watcher rules, right? Where this would be. So, I mean, we could potentially strip that out later, and then that should take care of the fiscal note if that was a portion we didn't really care about or wasn't as important as others. We could potentially, if it sits on the table, strip it off with the table process and pass the rest of it without a note as an option.
I would say it says in a little blurb that it's both for the rulemaking and for the preparation of instructions. I don't know what the monetary breakdown is between them.
All right, so is the majority comfortable asking Janet to challenge the fiscal note? Yeah, okay. Chairman Lucchini, did you have another question?
No, sorry, I'm not used to the hand thing.
Senator Hickman.
Yes, thank you. I missed the fiscal note on this bill. So if I could just hear what it is, that would be great. I appreciate it.
So part of the majority amendment requires, or actually it just says may adopt rules governing poll watchers and additional party workers and others present. And then also part of the amendment requires, as opposed to makes it discretionary, the Secretary of State to prepare instructions for absentee voter about the no excuse absentee deadline and what the excuses are that are allowed afterwards. And so this looks like it's $1,800 to do both. And I don't know what the breakdown is between the two.
Thank you.
Okay, any other questions or concerns from the majority on the language review? All right, seeing none, is that it for us, Janet, from your perspective?
Yes.
All right, Chairman Lucchini, you want to close us out?
Sure, yeah, and Janet, so yeah, we'll probably be in tomorrow at 10. I think we're going to plan to meet at 10. The exact order, we don't know. We'll just work on scheduling. But I plan to start at 10, and we'll just see when both Sam and Janet are available for each topic. And yeah, I think we'll just go through everything that's left pretty much. So it's gambling, marijuana, and a couple other leftover bills.
Do we need any specific instructions for 554 from today at all, or are we okay?
Yeah, I mean, I think if the tribes and the AG's office can communicate with each other on possible solutions, I think that would be great. I know the timeframes are tight, so yeah, I definitely encourage them to, or authorize them to, work together on that language. I don't know if I was clear on that. Probably wasn't clear enough on that earlier. I just know that, yeah, I mean, it would be great if we can find, whether it's even just through email, finding a possible solution, sending it, running it back and forth, something like that would be great, because I think we can clean it up, hopefully get something ready for tomorrow.
All right. Any other comments, questions, concerns from the committee? Okay, seeing none, then everybody enjoy the rest of your day and your other committees, those who have them. And we will see everybody tomorrow morning, 10 o'clock, I believe is the start. I think that's what Chairman Lucchini said. And if we need to meet before then, we'll be sending out notices to the caucus if we need to get together before then. So thank you, everybody. Get rested for tomorrow. It's going to be a big day tomorrow. So we'll see you all then.